Thank you so much for joining us here today for Professor Daniel Botansky's Masterclass on how to think like an international environmental lawyer. I'm Rayla Puno, and I'm a research associate at the NUS Center for International Law. I'd like to remind our audience that there will be a Q&A after the lecture. Please feel free to submit your questions at any time through the Q&A function below. CIL's director, Dr. Nilofer Ural, is unfortunately on travel and could not join us today, but she has kindly prepared her recorded welcome remarks, which we will now play.
Greetings from Singapore. As Director of the Center for International Law at the National University of Singapore, I am delighted to welcome you to this masterclass session delivered by Professor Dan Bodansky, who is currently at the Center for International Law as a visiting distinguished global scholar. Professor Bodansky is a world-renowned expert on climate change and international environmental law. And as CIL, we are very pleased to organize this online masterclass on how to think like an international environmental lawyer. I also take this opportunity to thank the CIL team, Danielle Yao, herself an expert in climate change and environmental law also, and CIL research assistant Rayla Puna for all their efforts in organizing this event. I know this will be a most enlightening and insightful lecture by Professor Bodansky. I wish you all the very best.
And now I have the honor of introducing our lecturer for today. Center for International Law's visiting distinguished global scholar, Professor Daniel Bodansky. Professor Bodansky is a foundation professor of law at the Sandra Day O'Connor College of Law of Arizona State University. He's a preeminent authority in international environmental law and is a prolific and celebrated author on the topic. His book, The Art and Craft of International Environmental Law, received the 2011 Sprout Award from the International Studies Association as the best book published in the field of international environmental studies. Let us all welcome Professor Daniel Bodansky.
There we go. Thank you, Rayla, for that introduction, and good afternoon, good morning, good evening to all of you, wherever you might be around the world. So my talk today is about how to think like an international lawyer. And I picked this topic because I think in many respects, how to think like an international environmental lawyer differs from how to think like a lawyer. I remember a friend of mine who was another international environmental lawyer once said, part of the issue is how to think not like a lawyer when one's doing international environmental law. So my talk today is going to be about how one approaches problems as an international environmental lawyer. And it's prompted by the fact that I'm currently working on the second edition of a book I wrote on international environmental law called The Art and Craft of International Environmental Law. I wrote the first edition really almost 15 years ago. It was published a dozen years ago. And I'm now working on a second edition. And so this talk is about how to think like an international environmental lawyer 2022 edition, what's the same and what's changed from the first edition of the book I wrote. So let me just spend the first part of my talk talking about what I said in 2010, what some of the main themes of the book were, and then discuss a little bit what's changed and what's going to be different in the second edition of the book. So the book, The Art and Craft of International Environmental Law, it's multidisciplinary and pragmatic. And there are 5 key points that I want to emphasize. First of all, it's process-oriented. Secondly, it discusses international environmental law as a distinct field. Third, it describes international environmental law as what I call a 30% solution. Fourth, it's very treaty-centric. And fourth, it's focuses on effectiveness rather than on it's focused on effectiveness rather than on compliance. So let me discuss, first of all, the first point, the process-oriented nature of international environmental law. Many books on international environmental law focus on doctrine, but the Art and Craft of International Environmental Law focuses more on the international environmental law process. How does international law emerge? How does it develop? How does it influence behavior? Who are the principal actors? What motivates and determines their behavior? Why and how do they develop international environmental rules? And why and how do those rules then in turn influence behavior? So I think we can approach international environmental law from three perspectives. The first is a doctrinal perspective, and this I think is the typical approach to international environmental law. The question there is, what does the law provide? And then we look to the sources of international law to try to answer that question, to treaties, to custom, to general principles. A second perspective in international environmental law is more of a policy perspective, focusing on questions of legal design. What should the law provide? How should it be? Written? What should be the goals? What form should we pursue those goals in? Public or private forums, global or local forums? Which kinds of policy instruments would best be able to achieve those goals? Who should the regulatory target of our regulatory efforts be? Should they be states, individuals, business entities? And what kind of compliance procedures are going to be most effective? A third perspective, both the doctrinal and the policy perspective, essentially view the law from the inside, trying to understand the law as a lawyer would in terms of what it provides and how it should be designed. The third perspective is looking at the law really from the outside as a political scientist. How do norms emerge and affect behavior? These are causal questions about what explains the development and influence of international environmental law. Who are the principal actors? What factors influence their behavior? How and why do legal norms develop, and how do they influence others? And as I suggested at the outset of my talk, the art and craft of international environmental law focuses much more on these latter questions of policy and explanation, rather than on the doctrinal perspective, which is the more typical approach. So many other books on international environmental law go through all of the different doctrines of international environmental law, but I think it's important to try to understand from a process-oriented viewpoint how international environmental law works, what explains its development and influence, and then how can we use those explanatory accounts to try to develop better international environmental law policies. So my second general point about international environmental law is I think it's a distinct field. We can understand, this has been actually somewhat controversial. Some of the early writers about international environmental law said basically international environmental law is simply international law as applied to the environment. There's nothing special about international environmental law. It's taking the basic rules of international law and applying it to environmental issues. We can think about international environmental law as a distinct field, I think, in two different senses. One is just simply a weak sense where it's discussing a distinctive subject matter. And in this sense, it's compatible with the view that international environmental law is simply international law applied to environmental subjects. But there's a stronger sense, and this is the sense I mean, of what international environmental law as a distinct field might mean. It's that there are distinctive secondary rules about how law is created and applied in the international environmental field. It's really different in more fundamental respects from other areas of international law than simply by virtue of its subject matter. So international environmental law has its own distinctive approaches to standard setting. Rather than having static treaties, treaties in the international environmental law realm tend to be dynamic. They evolve substantially over time from where they began. So there are different techniques for doing this. One is to start with a framework convention and then develop protocols subsequently. Another is to build in amendment procedures that are easier than the typical amendment procedures in international law that allow for the treaty to evolve more rapidly in response to new problems, in response to new information about problems. And a third technique is to elaborate the regimes through decisions of the parties. So there's now, for most treaty regimes, extensive decisions by the parties interpreting the treaty, elaborating the treaty, developing more specific procedures under the treaty. And in all these respects, international environmental regimes are distinctive, I think, from many other areas of international law. They're not simply treaties adopted at a single point in time. They're evolving instruments, they're dynamic instruments. A second distinctive feature of international environmental law is the importance of soft law. the importance of rules that are not legally binding, either that are agreed to by states or that are agreed to by private actors. And soft law, again, is a feature in other areas of international law, but I think it has a much more central role in the international environmental law process. As I just said, one aspect of soft law is private standard setting. So there are extensive regulatory regimes. They're not official governmental regulation, they're not legally binding, but regulatory regimes that have been developed by the private sector rather than by governments. A second way that international environmental law, I think, is distinctive in terms of its institutions. The Conference of the Parties, which is the central institutional feature of international environmental law, is sui generis. It's not exactly like an international organization, but it's not simply a one-off meeting forum among parties. It's an ongoing institution that has played a central role in the development of international environmental treaties and the regimes they establish. Similarly, the compliance procedures, the implementation committees established by international environmental treaties, again, are more political in many respects than they are legal institutions. They're comprised of government representatives typically, rather than by independent experts. They are, well, as I'll talk about in just a minute, they're more forward-looking than backward-looking. So in both of the two key institutions established by international environmental law, I think are distinctive from, for example, the kinds of institutions that are established in the human rights arena, which are much more legal in nature. And then finally, I just mentioned compliance. International environmental law has taken a different approach to compliance than other areas of international law. In other areas of international law, traditional international law that focuses on state responsibility, it tends to be backward-looking, looking for breach of international obligations, which give rise to state responsibility, tends to be adversarial, and that then other states that are adversely affected by the breach can invoke the responsibility, engage in dispute settlement, resulting in some cases ultimately in restitution and compensation. And the theory of state behavior here is that states are violating treaties if benefits outweigh costs, and we need to either raise the costs of violation or lower the costs of compliance in order to get states to comply. International environmental law, in contrast, takes a much more managerial approach to compliance, which tends to be forward-looking, trying to promote future compliance rather than adjudicate responsibility for past non-compliance. It tends to be non-adversarial. In fact, the states that most frequently invoke non-compliance procedures are the states that have not complied themselves, because the focus of the non-compliance regimes is to promote future effectiveness rather than to adjudicate past non-compliance. So the approach tends to be to work with the countries to achieve compliance going forward through, for example, developing compliance action plans or by providing assistance. So the response in many international environmental regimes to non-compliance by a state is not to adjudicate blame, impose consequences, negative consequences. Instead, it's trying to work with the country to try to figure out why it wasn't able to comply and to figure out what can be done to promote stronger compliance in the future. And the assumption here is that states are not simply calculating costs and benefits and violating treaties whenever it serves their interests. The assumption here is that states are the product of socialized environments that lead them to, generally speaking, not always, of course, generally speaking, to want to comply, where the reason for non-compliance is not so much bad faith, it is lack of ability to comply, lack of the wherewithal to be able to comply. So in all of these areas, in terms of the development of norms, in terms of the institutions, in terms of the response to non-compliance, international environmental law has quite distinctive features. There's a blurring of the line, I think, in international environmental law between the political and legal, because institutions like non-compliance committees tend to be as much political as legal institutions. A blurring of the lines also between public and private, because a lot of the standard setting, as I mentioned, is by private actors rather than by states. And there's finally a blurring of the line between international and domestic, because international environmental law, to be effective, needs to change what's taking place within countries' domestic political systems, within their domestic economies. And as a result, a lot of the activity in the international environmental regime is a lot of the activity is within a state, is by subnational actors like cities and states, rather than simply by the national government itself. So some people criticize international environmental law for these distinctive features. They say that, for example, that international environmental law is eroding the concept of state responsibility and the concept of compliance by being more political in nature. That in some senses, international environmental law is not sufficiently legal in nature. But I guess part of the theme of my lecture of how not to think like a lawyer to be an international environmental lawyer is that I think a lot of these distinctive features of international environmental law, in fact, have considerable justification. Environmental problems have a number of distinctive features. They're caused primarily by private conduct. So the involvement of businesses and non-governmental entities, other non-governmental entities, is much more essential than it is in areas where the conduct in question is primarily state conduct, which is of concern. International environmental issues have a strong scientific and technological component, so that the role of science in the development of international environmental law is essential. International environmental problems are highly uncertain, and they're also rapidly changing in many cases. Problems of one kind then morph into problems of a different kind. So international environmental regimes have a particular need to be dynamic, to be able to be changing over time to respond to our better understanding of problems and to the changing nature of the problems themselves. And international environmental law is highly interconnected. Taking action in one area has implications for others. So we need to be able to address issues in a very holistic way. Now, my third point about international environmental law is, so I think I describe international environmental law as a 30% solution. And by that, 30%, of course, is not a mathematically calculated number, but it's to suggest that international environmental law is not a panacea. International environmental law, like international law generally, is a tool that can be used to address problems, but it's not necessarily a way to solve every problem. Not every problem is susceptible to a legal solution. In cases where states have an interest in dealing with a problem, and the stratospheric ozone depletion problem is a good example, where states have an interest in addressing a problem, then international environmental law can serve as a tool to allow states to achieve their ends, to be able to solve the problem by, for example, making commitments more credible, by providing for reciprocity between states. It can also play a role in social learning and promoting more information, which can change states' understanding of their own self-interest over time. So it's a way to move the ball forward, but it's not necessarily a solution in every case, or it can't solve it by itself. Some people, for example, blame the fact that we haven't done more to address climate change, which is a huge, huge problem. They blame it on international law, but international law, I don't think, is responsible for the slow pace of progress on climate change. The problem is that there's, in many states, a lack of sufficient political will to take action. Many states are reluctant to take action, and where states are unwilling to take action, international law, international environmental law, is not able to force them to take action, and I'll come back to that a little bit more in a minute. There are two conceptions of international law, I think. One is to think of international law as a stick, where international law imposes constraints on behavior, where it provides them for compulsory dispute resolution, sanctions for violations. This is very much a domestic model of law, where law can operate much as it does in the criminal law sphere domestically. And if this is the way we think about international law and international environmental law, then the solution is we need new institutional authority, which can develop new rules, which can, in a binding way, adjudicate violations of the rules, which can sanction violations. And I think this way of thinking about international law as a stick, then leads one to think that one needs new institutional authorities, like establishing ecocide as a crime, which the International Criminal Court can hear prosecutions for, or establishing a World Environment Organization, which would have much stronger powers to develop new rules and to apply and enforce those rules. So that's one model of international law. But I think the model of international environmental law that we see in practice today, which I think is really what international environmental law is able to do, at least in the current political structure, is to see international environmental law more as a facilitator, not as a stick, but as a means to encourage and enable more cooperation between states, which can help build cognitive and normative consensus over time. So states have a different understanding of their self-interest, a different understanding as the appropriate way to behave, and that can address barriers to cooperation, such as mistrust and lack of capacity. How to think like an international environmental lawyer, at least as international environmental law currently exists, is to try to think about how international environmental law can act as a facilitator to encourage more cooperation over time, rather than to think about how it can be used as a stick to compel greater action. And in trying to think about what international environmental law can do as a 30% solution, as a means of facilitating action over time, the art and craft of international environmental law suggests the diagnostic method, where one tries to identify the obstacles to cooperation and then tries to look at the role of international environmental law in addressing those obstacles. So in the case of many environmental problems, one of the obstacles to more cooperation is uncertainty, uncertainty about the science, scientific questions remaining about, for example, in the 1980s, whether acid rain was really a significant problem, about climate change today. And so to the extent uncertainty is a problem, one role that international environmental law can play is to promote scientific research, to develop cooperative scientific research programs, which can produce better information and can address those sources of those obstacles to cooperation. In some cases, the obstacle to cooperation is it's a collective action problem where each individual state has an incentive to keep polluting, but if everyone keeps polluting, then everyone is worse off. So one needs to be able to provide for collective action where everybody mutually agrees to reduce its pollution in order to produce a collectively better result. And here, the role of international environmental law is to try to change the incentive structure, to try to raise the costs of not cooperating and to decrease the costs of cooperating. And one of the things that international environmental treaties attempt to do is to make commitments more credible through reporting and review, so that if one country agrees to reduce its emissions, it can have a higher degree of confidence that other countries are going to reciprocate and reduce their pollution in response. Another obstacle to cooperation in many cases is domestic politics. It's not a question of so much of collective action, of trying to get everyone to cooperate. It's that individual countries have domestic politics makes it difficult for them to take action. And I think this is much of the reason why climate change has not made more progress. And here, the role of international environmental law can be to try to help empower domestic groups to try to change the political dynamic within a country by giving proponents of action some tools to be able to use to try to promote stronger action within a country. International environmental law can do this by raising the prominence of an issue, by issuing reports that give domestic groups who are in favor of stronger action some tools they can use to try to promote stronger action. So a lot of what international environmental law tries to do, I think, is to give non-governmental groups, elements of a state's bureaucracy, that are in favor of stronger action, some extra tools they can try to use to try to promote stronger action within their country. A fourth kind of barrier can be lack of legitimacy, and here the international environmental law needs to try to do better in addressing equity issues and providing for more public participation to promote stronger legitimacy. And then a final, I think, significant obstacle to international cooperation is lack of domestic capacity. And here, international environmental law can help provide financial and technical assistance to give countries the ability to be able to do more to protect the environment. So how do we evaluate the success of international environmental law? Here, I think it's useful to distinguish three different meanings of effectiveness. The first meaning is legal effectiveness, and this is what lawyers typically focus on, is compliance, congruence between what a rule provides and how an actor actually behaves. But compliance in the international environmental realm is really insufficient because in many cases, if an international environmental rule is very weak, you can have complete compliance, and yet the rule is doing very little and actually changing things for the better. So in international environmental law, I think there's been a move away from looking to compliance as the measure of success, and instead focus on how much the rule has actually changed behavior. How behaviorally effective is it? Does it, for example, require states to be doing things to implement the treaty in a positive way? And then finally, the third way of thinking about effectiveness is problem-solving effectiveness. How close or how much progress has the regime made in actually solving the problem that it seeks to address? And I think if we focus on, in particular, problem-solving effectiveness, one needs to then has implications for how we think about how to design a regime, a treaty regime, because problem-solving effectiveness is a function of several different factors. A lot of people, when they talk about how good a treaty is, focus on how stringent the commitments are. So they equate a better treaty with a treaty with more stringent commitments. But in fact, problem-solving effectiveness is not simply a function of the stringency of commitments. It's also a function of how many states are participating, whether the biggest contributors to the problem are participating in the treaty regime, and it's a function of how well states are doing in terms of complying with the commitments. You can have a treaty with extremely strong commitments, but if the key countries are not participating in the treaty, or there's a low level of compliance, then the treaty is not going to be effective. Conversely, you can have a treaty for which there's 100% participation and 100% compliance, but if the commitments are very weak, again, you have you don't have an effective treaty. So the problem in developing international environmental regimes is how to maximize the output, which is a function of stringency, participation, and compliance. How do you get the best in trading off? And there's trade-offs. The more stringent the commitments, the less participation or compliance you have. To get more participation, you typically have to weaken the stringency of the commitment. So what is the best combination of these three variables to yield the strongest output in terms of problem-solving effectiveness? So the final point of the way the art and craft of international environmental law is written is it's very treaty-centric. It focuses primarily on treaty regimes to address environmental problems rather than on other areas of international law. And I think up until recently, at least, most of the action in international environmental law was treaty-based. Why have treaties been the preferred approach to addressing international environmental problems? I think there are several reasons. They allow states to address issues in a purposive, rational manner. They can promote reciprocity by allowing states to delineate what each side is going to do. So one state says it's going to do something in exchange for a precisely defined commitment by the other state. Because it's in written form, what I call a canonical form, it provides greater certainty. When we talk about customary international law or general principles, huge amount of uncertainty as to what they actually mean. And finally, treaties allow states to tailor institutions to fit the particular problem. So in a treaty regime, you can establish non-compliance committee. You can establish a financial mechanism. You can establish particular monitoring and reporting kinds of requirements. So you're able to tailor the institutions in a way that if you're relying on general international law, custom, and general principles, you're not able to have that kind of a customized approach. So a lot of the art and craft of international environmental law is then looking at design issues and designing international environmental agreements. And I think one way of thinking about these design issues is in terms of the various functional tasks that a treaty has to achieve. It needs to have participation because, as I mentioned before, without participation, an extremely good treaty is not going to be effective. It needs to be able to provide for flexibility to be able to respond to new problems and new information. It needs to be able to evolve and grow over time, and it needs to be able to promote compliance. So you have these functional tasks, and then there are various variables in treaty design that you can try to use to try to achieve these functional tasks. You can try to look at the geographic and substantive scope of the agreement. Do you have a regional agreement or do you want a global agreement? There are a number of different issues relating to the norms or commitments that you can focus on in terms of treaty design. Are they hard or soft, legal or non-legal, precise or vague, common or differentiated? They're the institutions of the treaty, they're the amendment procedures, they're the dispute resolution procedures, and there's the various carrots and sticks that one can include in a treaty, various provisions for support and assistance, trade measures for non-compliance. So a very wide range of treaty design variables involving scope, commitments, institutions, and so forth that one can try to then use to try to design a treaty that achieves the various functional tasks that I have up here on the left. So let me just give you a few examples of this. So one issue that doesn't get much attention, usually choice of negotiating forum and mandate. Depending where you negotiate the agreement is going to have an influence on what kind of subject matter it's going to deal with. One can try to encourage participation by developing a mandate that's widely acceptable. So an issue in the climate change regime initially was, do you negotiate it under the auspices of the UN Environment Program and the World Meteorological Organization, which was, I think, what many people expected, or under the UN General Assembly? And one initial design choice that was made was to negotiate the Framework Convention on Climate Change under the General Assembly, because the General Assembly has a much wider mandate than environment or meteorological issues. Developing countries wanted climate change to be addressed as a development issue, as well as an environment issue, and therefore insisted on negotiating it under the auspices of the UN General Assembly. One has a wide range of commitments types one can use in treaty design. Command and control regulation, the convention dealing with oil pollution from ships takes a command and control approach. There are many different treaties with permitting schemes, for example, dealing with trade in endangered species. In some cases, the problem one's trying to address is an informational one, and in those cases, a prior informed consent regime can be used, and this has been used in the chemicals area to address exports of hazardous wastes, trade in hazardous wastes, and trade in chemicals, where the importing country may lack the information necessary to make an informed choice, and where the treaty then requires provision of information to importing countries and allowing them the ability to make an informed choice in advance before the shipment takes place about whether they want to allow it. And then in some cases, treaties establish obligations of results. So there's a wide range of commitment types one can choose among in terms of treaty design. One issue that's gotten increasing attention in recent years as a treaty design variable is how binding the commitments are. And I think it's important when one's talking about the bindingness of commitments to distinguish four elements of bindingness. Is the agreement itself binding? Is it a treaty, or is it a resolution or political agreement? Treaties are binding under international law, whereas resolutions, political agreements, typically not. But then within a treaty itself, are the provisions phrased in mandatory or non-mandatory terms? So one of the big issues in the development of the Paris Agreement on climate change was which provisions. So one issue was whether the Paris Agreement would be a treaty or not. And the answer to that was it was adopted as a treaty. But then which provisions in the Paris Agreement itself are binding and which ones are simply recommendations or permissions. And so the choice of verbs, shall, should, may, will, is a key issue for international environmental lawyers in treaty design. How precisely are the rules stated? Are they phrased in very precise terms so it's very clear what countries have to do and whether they've complied, or are they phrased in much more general terms as what's sometimes referred to as standards rather than rules? And then how much international supervision and enforcement is there? Is there independent binding dispute resolution, or is it a more political process for international supervision involving state officials, non-binding outcomes, and so forth? So these are all different elements of bindingness which states can use in developing a treaty and treaty design to calibrate how binding the provisions are going to be. The more binding they are, in theory, the more compliance there's going to be. On the other hand, the less participation you might get. So there's going to be trade-offs here between compliance and participation. And by having these various different elements to play with, states are able to calibrate the bindingness of provisions to try to, in theory at least, with the hope of maximizing the effectiveness of the regime. How do you differentiate commitments? And here again, there's a very wide range of options available in treaty design. There's the question as to how you do the differentiation, who's differentiating. Is it done in terms of lists or annexes where you simply list the countries that have special provisions for them? Do you use some more criteria like per capita GDP where how a country is classified is going to change depending on whether it's met the criteria or not? Do you use a general descriptor as say developed countries have to do X, while developing countries have to do Y or don't have to do X? Do you allow countries to determine for themselves which commitments are going to apply to them? And this is the approach taken in some more recent agreements. So a wide variety of approaches, and these are heavily debated, I would say, in many treaty regimes as to who's entitled to differentiation, how those countries are defined, how much flexibility is there in changing their status over time. And there's similarly a wide range of options in terms of what you're differentiating. Are you differentiating which commitments apply to which countries? Are you differentiating the timing of commitments? So the Montreal Protocol says everyone has the same commitments, but developing countries have 10 additional years in which to comply. So there you're differentiating not the commitments themselves, but when countries have to achieve the commitment. Do you simply have a commitment, but then provide for some flexibility in implementing the commitment? So again, this is just to illustrate the very wide range of variables one can play with in trying to design a treaty that maximizes the output in terms of stringency, participation, and compliance. There are a number of different ways that treaties try to promote participation, which are discussed in my book. So you can try to add issues that countries to try to get them to participate because they want that issue addressed. You can subtract issues that are controversial so they don't need to worry about those issues if they don't want to have the issues addressed. You can lower the cost of joining by having differential standards, by providing assistance. One can reduce the so-called sovereignty costs of an agreement by allowing countries to self-determine what they're going to do rather than have it told to them in the agreement. You can give them a menu where they have options so they have more choice as to what their commitments are going to be. You can lessen the bindingness in the various ways I just mentioned, less precise norms, norms that are not phrased in mandatory terms, and so forth. One can give countries exit options. So if they have commitments they don't like, they get to exit those. So their sovereignty is still preserved by having the option of exiting from a particular provision. Requiring consensus decision-making, again, protects countries' sovereignty because no decisions can be taken without a country's agreement if the decision-making requires consensus. So again, a wide range of treaty design variables one can play with to try to address the concerns that a country might have that a treaty is going to limit its sovereignty and it therefore won't participate because it wants to preserve its sovereignty. Various design elements can try to provide states some reassurance that their sovereignty is still protected by giving them exit options, consensus decision-making, and so forth. And then some states might want to participate because they think a treaty is going to hurt their competitiveness. And again, treaties can try to address those competitiveness concerns, for example, by permitting trade measures against non-participating states, so a state can protect its competitive position. And then finally, a treaty can promote participation by increasing the cost of staying out. And here I think a number of treaties have used trade measures as a way to try to reduce the incentive of countries to stay out by saying, if you stay out, you can't engage in trade. So if you stay out of the Convention on International Trade in Endangered Species, states that are parties to that treaty, for example, then are no longer to trade wildlife with you. So trade measures deprive the state of the benefit of staying out or increase the cost of staying out and therefore incentivize greater participation in agreements. And then a final functional treaty problem is how do you build a regime over time? A treaty that might look great in 1990 might not look so good in 2010 as what we know about a problem changes in terms of the problem itself may have changed. So a whole series of different approaches international environmental law has used to try to build a treaty regime over time. So you can start with a softer law and then convert it into a harder law. So you can experiment first with a softer version that's not binding before states are required to decide whether they want to agree to a treaty or not. They get some practice, some experience. You can start with a very general agreement, a framework convention, and only develop more specific regulations later on in a protocol. We can start with a very vague text that doesn't require very much precise action, and then try to provide more precision over time, for example, through decisions of the parties. The Treaty on Wetlands, for example, says that states have to wisely use wetlands, very general, vague provision that's relatively easy to agree to. But then over time, through decisions of the parties, states have progressively fleshed out what wise use of wetlands entails, what kinds of measures the state needs to take in order to satisfy the requirement of wisely using its wetlands. And finally, you can start with more political approaches to dispute settlement to more legal ones. So the more political ones, less binding, but then over time, as the regime strengthens, you might then be able to get agreement on more legalized dispute settlement. One can start with asymmetric standards where some countries agree to something, but not everyone does, and then try to build out over time. So this is the approach of starting small and building out, starting with like-minded countries agreeing to something, and then developing a more global regime after this. This is one of the rationales for starting at the regional level. And only after you've got some experience with an issue at the regional level do you try to develop a more global regime. You might start with differentiated standards where only some countries are required to do things and other countries aren't, and then try to make the regime more universal over time. And then finally, there's the question of keeping the treaties up to date. And here, international environmental regimes, generally speaking, do this by dividing up the more general aspects of the agreement, which are in the treaty itself, and then having the regulatory materials, the specific rules in annexes that are able to be adjusted more easily, that don't require states to affirmatively consent to adjustments, allow adjustments to be made or amendments to be made by some kind of supermajority vote. They still preserve state sovereignty by allowing states to opt out of amendments they don't like, but they make the amendment process much, much easier than the traditional international law approach, which requires states to ratify each new amendment. And then you can also keep a treaty up to date through decisions of the parties. The more that you can resolve through decisions of the parties, the easier it is to add new rules or respond to new problems. Decisions of the parties typically are not legally binding, but nevertheless, they have significant effect on how states are acting. And through decisions of the parties, you can be much more nimble in a treaty regime in addressing new issues and new information. Okay, so that's just a brief overview. I know there's a lot of material in there on the first edition of The Art and Craft of International Environmental Law. It takes a process-oriented approach, looking at how rules develop, how they're implemented, how they're enforced. It doesn't view international environmental law as a panacea. It's a 30% solution. It can do some things, but not everything. It's distinctive in many ways from other areas of international environmental law in terms of how standards are set, in terms of its institutions, in terms of its compliance approach. It focuses primarily on treaty regimes, and then takes a functional approach to try to identify all of the different design elements one can work with to try to achieve functional tasks like promoting participation, promoting change over time, promoting stronger implementation. All right, so what's new? What's changed in the last 15 years since I wrote the first edition of the book? So in many respects, I think the changes in the last 15 years are really continuations of the same themes. So international environmental law has gotten wider. It's addressed a number of new issues like mercury. It's now addressing negotiations are beginning on plastics. It's addressed several new areas. In some ways, it's gotten deeper in the various ways I've suggested. Soft law has become harder law. The more precision has developed through decisions of the parties. There are even more design features now to promote participation that have been used in different treaty regimes. I'd say it takes a more nuanced approach to the problem of how you differentiate commitments between different countries. The notion that treaties are elaborated by decisions of the parties, I think that idea, which was around 15 years ago, has been used much more by states in developing rules for example, how the Paris Agreement are going to be working. So some of these different aspects of international environmental law that I've been describing so far that were in the first edition of my book, I think really have been continued and flourished over the last 15 years. But there's a number of ways I think that international environmental law has maybe more fundamentally changed. And I think maybe the most important is the increased role of international courts and tribunals. So when I wrote the first edition of Art and Craft of International Environmental Law, there were really still extremely few cases before courts involving international environmental law. There was just a handful of cases. Since then, there's been an explosion of litigation, particularly in the area of climate change, both nationally, but then also internationally. And many of the national court decisions have used international environmental law in reaching their outcomes. So this is, I think, a significant change. I edited a volume maybe 20 years ago on how international environmental law is used in national courts. And there were very few examples back then, very few examples of national courts using international environmental law, but that's changed significantly over the last 15 years, along with the increased amount of litigation in international courts. There's, I think, a much more expansive use of private regulatory activity. So I mentioned earlier that international environmental law, really from early on, has involved the development of private standards developed not by states, but by private actors. But I think the increase in the amount of this private regulation that takes place has really, its difference in degree has become a difference in kind almost, because the amount of it's much greater. I think there's also a greater engagement with non-state actors by international environmental regimes. And you can see this strongly in the climate change arena. And then finally, there's the whole area of how international environmental law intersects with other areas of international law, what I call here international environmental law And what can follow the and there could be human rights law, international environmental law and human rights law, trade law, investment law, intellectual property law. So let me just briefly describe these developments and then close out. So, the 2022 edition, assuming it's, or the 2023 edition, is going to be focused more than previously on the importance of private governance because of the increasing role of courts, the importance of doctrine, because courts apply doctrine, and international environmental law, and raises the question of interrelationships and how do you develop an architecture. Just to illustrate the increasing role of non-state actors, these are showing initiatives in the climate change arena. Almost 30,000 non-state actor initiatives have been registered under the Climate Action Portal. In terms of the increasing role of courts, on the right are the Urgenda and Shell decisions, both in the Netherlands, and then on the left is the International Court of Justice, where it's likely that the General Assembly will be requesting an advisory opinion on climate change from the International Court of Justice soon. And then, as I mentioned, international environmental law and has really taken off in a big way over the last decade. So intersections with human rights law, intersections with trade law, intersections with intellectual property law, and so forth. So I think to be an international environmental lawyer today, one still needs to think, one still needs to learn how not to think like a lawyer in some of the ways I was talking about before. But it's also, I think, increasingly important to understand the intersections between international environmental law and other areas of international law, to understand the role of courts and how doctrine might be applied by courts. And finally, to look not only at what states are doing, but increasingly to look to what non-state actors are doing. So, so those are some of the key changes over the last 10 years, at least that I see, in terms of how to think like an international environmental lawyer. So thank you very much for your attention, and I look forward to your questions.
Thank you very much, Professor Bodensky, for that really interesting take, I would say, on how not to practice like a traditionally one would think of approaching international law. And particularly for those who are on this session, I mean, there are plenty who are, I've noticed on the registration, and we're out really around the world, from governments as well. And what you've shared will be very, very almost like a roadmap as to how to negotiate a successful international environmental treaty. And there's actually lots of questions, and that makes my role as a moderator very, very easy, because there are lots of questions. And maybe what I can do is to try and bundle them together in a few clusters. One cluster is really looking at what you've described in your discussion. What can law schools or professional training associations do to really lawyers today to think like an you describe? You've got to be political scientists, you've got to be a social scientist, economics, you've got to be aware of geopolitics and business and private governance. It seems a lot to chew on. So that releases some question: how can one, what advice would you give to somebody entering the field? So that's one set of questions. Perhaps I could leave that with you first.
Well, so when I teach international, I teach international law, public international law generally. I teach law of armed conflict. I've taught trade law, and I teach international environmental law. And I teach international environmental law very differently than I teach the other subjects, because the other subjects I tend to teach in a much more traditional way. So when you're looking at law of armed conflict, what are the rules for the use of force, or what does the Geneva Conventions provide in terms of targeting decisions or decisions about how to distinguish combatants and civilians. So it's very doctrinal. It's very focused on what the rules are. Similarly, when you teach trade law, there's a huge jurisprudence of WTO dispute settlement that you would look at. So again, it tends to be quite doctrinal, and it's very, actually, in some ways, I like teaching those courses the most, because they're very familiar as a lawyer to teach those courses, because you're focused on traditional kinds of legal materials and similar kinds of issues about how do you interpret the rules, how do you apply them to particular factual contexts, and so forth. When I teach international environmental law, I don't find that a very fruitful way. I know some people do teach it that way, but because I don't think international environmental law, at least thus far, has developed primarily in terms of thinking about the duty of due diligence and how it applies in particular context, or looking doctrinally at the precautionary principle. And it's really developed primarily through the elaboration of treaties, treaty regimes dealing with climate change and ozone. And there, you can focus on the particular rules the treaty provides, but really, I think the more interesting question is how they're designed. What are all these different design elements? And so that's actually much more difficult to teach. And I think personally an experiential approach where you try to teach them some of the different tools, but then try to give them a negotiation so that they can then work with these treaty design elements and think about how they might apply in addressing a actual issue, such as plastics, regulation of marine plastics, or one that I like because I'm interested in the issue of climate engineering, is how would you develop a treaty on climate engineering, and what kinds of treaty elements might that include? So I think trying to have more experiential learning, trying to put them in the position of trying to think how these different design elements might work out, from the context perspective of a particular country addressing a particular problem, I think is a useful approach. I do think, actually, in working on international environmental law, to the extent one is able to get a multidisciplinary approach, the better. So understanding some economics, I think, is helpful. Having some background in international relations. I don't think you need to be experts in those areas, but you need to at least understand, be able to understand it at some basic level. When I go to meetings, I'd say at most meetings I go to, it's not primarily lawyers. I mean, if I go to the European Society of International Law meeting, that's lawyers, of course. But when I go to international environmental meetings, climate change meetings, for example, lots of political scientists, economists, in some cases sociologists. So I think being at least somewhat conversant in those other disciplines, I think is helpful. Knowing what a collective action problem is, understanding prisoner's dilemma, understanding some basic microeconomics. So I would highly recommend to students thinking of going into this field, to try to get some broader exposure to some other disciplines as well as law.
Okay, thanks very much, Dan. I think that's very helpful. I think it's how do you factor in an interdisciplinary or multidisciplinary focus that seems to be something quite unique about environmental law, from my own personal perspective. If I may move up to the next set of questions, and this really focuses on evolution. During climate change negotiations, during the drafting, and we don't just see this in climate change, we see this in the Montreal Protocol context, we see this in the CITES context. Lots of what you say regulatory type decisions are actually taking place at the COP level. And so you have a framework agreement, and you have many different decisions, resolutions. The question really is, how do they influence evolution? Should they be progressively being looked at in terms of evolution or even amendment, even though they're technically not supposed to be? And that's one question. Another question related to that is really what should lawyers pay attention to during the negotiations, particularly during the drafting of these decisions, which, as you say, bringing a lot of political and other elements. How should actually lawyers interpret such a decision? So many of them are not really drafted in necessarily tight technical language, and perhaps deliberately so. I guess that really, how does that reflect some sort of new principles, particularly that's somehow unique to the IEL space?
So first of all, in terms of decisions of the parties, I think it's quite interesting, and I think they illustrate my point about how not to think like a lawyer. So a lawyer, you might think the first issue, the overriding issue, would be, are the decisions binding or not binding? In most cases, conferences of the parties, their constitutive treaties don't give them binding decision-making authority. So the decisions are only recommendations, but then in some cases, the treaty might give the conference of the parties ability to make binding decisions. But I think at the end of the day, in the world of international environmental law, whether the decisions are binding or not binding doesn't make that much difference. Maybe if you were able to bring a case involving one of these questions before the International Court of Justice, then they would need to decide whether or not the decision is binding. But whether or not the rules, so there was an issue in the Paris rule book as to whether the rules on accounting of nationally determined contributions, whether those are legally binding or not. And I think, if I remember right, there's some question as to whether the language in the Paris Agreement actually gives binding authority to the COP on those. But in the real world, I don't think states, the decisions have the same effect whether they're binding or not. They serve as, the negotiating process itself leads to some convergence of views behind the rules. The rules wouldn't be adopted by consensus unless states were agreed on what the rules provide. So I think the rules have a significant steering effect, and serve as a basis to evaluate what a state is doing as to whether or not they've complied with the decision or not, whether they've satisfied the decision or not, I should say, because I would reserve compliance only to those that are legally binding, but whether their actions are congruent with what the rules provide. I think that's the case whether the rules are binding or not as a formal legal matter. So I think obsessing about the legal nature of the rules or not is something that one would have to worry about if it was in court, but in international environmental law, one very rarely is in court. So they make less difference. So I think lawyers need to be involved in virtually all aspects of a treaty design. So it's not simply that they look at the treaty. I remember look at the treaty at the end and clean up the language and so forth, because really, the entire treaty is a drafting exercise, and lawyers are good at drafting. And in some cases you want precise language, but in many cases you don't want precise language. You want what some people refer to as constructive ambiguity. So trying to calibrate the language to achieve your state's objectives that's largely the role of the lawyer, is to try to work with the language of the text. And often the solution to problems is a linguistic one, is finding the right words that bridge the difference, that allow states to reach agreement. And so I think that kind of expertise in drafting, now it's not specifically, it doesn't require a lawyer in all cases, but I think it tends to be something that legal training makes one better at, is working with language and being able to find the right set of words that will achieve your country's objectives or your group's objectives if you're working for an NGO or business, but also being acceptable to others.
Thanks very much, Daniel. I know we've kind of ran past the hour, but there are just a couple of really interesting questions. So you're going to be prevail maybe another 5-10 minutes if it's all right. Let me just drop 2 questions from the list which I thought was quite interesting. And the first is, of course, a question whether how you relate this IEL approach that you had mentioned in this discussion. How do you approach it to governance? Because there seems to be a lot of similarities between the key concepts of governance, such as institutions, the actors, that seems to resonate with your approach. So there's a question here whether how do you differentiate, or is there any difference really between what you said and your approach to governance and approach to legal treaty making and negotiations? The second is actually more a question that I wanted to throw out as a challenge, because you mentioned this in your presentation. You'll be interested in looking at the design of a treaty that looks at geoclimate engineering or things like that, or plastic. And one of the questions here is that really, what is the role of international environmental law regarding the deployment of CCS technologies? Now that seems quite specific. I wonder if I could broaden that to say that broadly in terms of climate, in the area of geoengineering, CCS, which really brings in not just environment, climate, but law of the sea, many different disciplines, as well as a large role for private sector being the ones who are involved in such activities, questions of liability and insurance as well, which brings in domestic law, not just international. How would you design a treaty? What would be the design aspects that one ought to look at? Should there ever be a move towards a treaty that looks at those kinds of issues, or even an evolution of the current treaties to incorporate those elements?
So I think my approach to international environmental law is broadly similar to approaches of political scientists, international relations theorists who focus on international governance. So I think there's some significant convergence between the two approaches. I guess I would say most of what I read about governance in the international relations literature typically doesn't get into the kind of detail on treaty design questions that I was mentioning. They tend to deal with things at a higher level of generality. Now, that's not always true. There's a group within the international relations community focusing on rational design of international institutions, including agreements. And there's been a lot of work done by Barb Koromanos in particular, looking at treaties and different design elements of treaties and trying to then draw some deal with them in a quantitative way in terms of different design elements and what functional purposes they serve. So there's some examples of that, but I would say typically the governance literature is less focused on the details of these kind of treaty design questions and more focused on broader elements. I remember, but there's been a significant, I think in the international environmental law area, was an early area where there was quite a lot of interaction between the international relations community and the international law community because there's a significant overlap. So the work I mentioned on compliance and different approaches to effectiveness, a lot of that comes out of the international relations literature. But I just tell you one story that I think illustrates a little bit of the difference still between the two. I was I was a discussant on a very early panel back in the early 1990s involving IR and IL, International Relations, International Law, and they were discussing the Framework Convention on Climate Change. And so one speaker was an international lawyer and the other was a political scientist. And so I started my comments by saying that I think one of the differences between international law and international relations is the international lawyer actually has read the treaty, whereas the international relations person is just speaking in a broader term about the governance issues, but has never read the treaty. And the person who's the international relations blushed a little bit, and I think I had accurately depicted his background. So I think that's maybe changed some. So I think a lot more international relations theorists now do in fact read the treaty. But I think reading the treaty is really where international lawyers would begin rather than something they would add on later on. In terms of designing a treaty, I'm not sure when you're talking about CCS. So I think there's so first of all, I think with carbon capture and storage, it does intersect with a number of different treaties. And this is one of the aspects of international environmental law that makes it complicated and that makes those architectural issues about international environmental law, and it's not just international environmental law, and it's how different areas of international environmental law themselves interact with one another and how you structure that, because CCS raises issues under the Paris Agreement, it raises issues under the London Protocol, it raises issues under the Basel Convention on Transboundary Movement of Hazardous Waste. So a lot of different treaty regimes are implicated by that. And so then the question is, how do you have some overarching treaty, or do you try to somehow address the interrelationships between the treaties themselves through some architectural arrangement? So so I tend to think one can try to address those interrelationships as between the treaties themselves and try to work them out to the extent the problems exist. A good example was the interactions between the Montreal Protocol and the climate regime, where the Montreal Protocol was encouraging the use of HFCs because they're not ozone depleting, while the climate regime was trying to eliminate the use of HFCs because HFCs are a very potent greenhouse gas. And so the two regimes were working at cross purposes with one another. And that was ultimately addressed by having the ozone regime amend the Montreal Protocol annexes to include and address the climate impacts of HFCs and not just the ozone benefits of HFCs. So I think there are ways of trying to allow the regimes to work together. And so I guess I think with these kinds of issues like CCS but many other issues as well that cross-cut a number of different regimes, it's probably better to, I mean, I don't know if there's a hard and fast rule on that, but I guess my first instinct would be to try to make the regimes compatible with each other before trying to have something more meta that addresses it in a broader way. I think there's a lot of benefits to having, a lot of people are worried about fragmentation of international law and treaty congestion, but I think different issues raise different problem areas raise different kinds of issues. And so having a more bespoke approach where you have different treaties taking particularized approaches to particular issues might make sense from a substantive standpoint, and also is, I think, critical in terms of trying to get participation by states in the different regimes.
Thanks very much, Dan. I think that's a very wise advice, not to chew off more than we bargained for in trying to come up with some meta comprehensive argument treaty. That there's always a tendency and always some suggestions to do that, and it's a useful advice to pause and take stock of where we are and whether there are actually more practical ways of, as you gave the good example of the Kigali Amendment, as to how the Montreal and the climate change regime can actually work together. We've reached about 4:45 now, so we've got an audience who'll actually stay with us all through. Just a testament to the really fascinating discussion. I really appreciate that. So before we end off, I wanted to just give you the floor one more time to see if there's any final words you'd like to say, because I know we didn't get a chance to go through your 3 models of international law, which I thought was very interesting. But perhaps you'd like to perhaps a final couple of sentences before we close this very, very interesting discussion.
So I think just in closing, I think it still is useful to think about international environmental law as a distinctive field, because I think it still has many distinctive elements. But I think one thing that maybe I didn't emphasize enough is that I think a growing convergence between international environmental law and other areas of international law, so that many of the kind of very detailed questions about the relationship of investment law and international environmental law do require one to think like a lawyer in the more traditional sense of the term, and not just how to think like an international environmental lawyer. So I guess I maybe leave you with that you still want to think like an international environmental lawyer, but I think you want to couple that increasingly with also thinking like a lawyer. So it's some combination of mirroring the two together.
Thanks very much. It's very thank you very much for those final words. It's leaves us with a lot to chew on now. Probably we will upload this on social media for those who want to review these comments again. But once again, thank you very much, Daniel, for this really fascinating hour plus, and also to our audience for participating, and really a wonderful, very interesting questions that have come up. And unfortunately, we didn't have time to go through every single one. But thank you, and wish everybody a good evening. Ryla, any other closing matters? If not, thank you everyone again.
Thank you everyone for your attention. Thanks.